Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at a case where, if the prosecution had gotten its way, it would have been illegal to shoot at a shooting range. And you might think I'm joking here or engaging in some hyperbole. That's actually what the justices say. So let's have a look at this case. It's a little wild. It is the case of the King and the very aptly named Preston Rat. All right. So this one is a Crown appeal from an acquittal. So in Canada, the rules are a little different than the US. The Crown, the government, can appeal an acquittal on questions of law. And so the issue is the proper interpretation of Section 244, sub 2, sub 1, sub A. And that says that every person commits an offense who intentionally discharges a firearm into or at a place, knowing that or being reckless as to whether another person is present in the place. And we'll have a look at the full language a little later. But the Crown contends that the trial judge misinterpreted this provision when he found it to require that, before a conviction can be entered under that section, a court must conclude that a firearm was discharged from one physical place into or at a different physical place. So the Crown's position, the government position on this one, was that if you fire a gun within one physical place, that would have been enough to get a conviction on that. Let's have a look at the facts here. And they just note here, the trial judge correctly interpreted this, so the Crown's appeal is dismissed. The Crown loses this one. That's sort of the spoiler. Let's see how they get to losing it. So we'll start with the facts. On January 25th, 2021, Mr. Rat was at a one-story house with several others. He had a shotgun. One of the others present, the complainant, decided to leave. As she was readying herself to do so, there was a knock at the door. Mr. Rat grabbed the shotgun, loaded it, and pointed it at the front door. He shouted, "Who's at the door?" He did not fire the gun. Mr. Rat is maybe starting to sound like not the nicest person here, maybe not the most stable human being. So let's continue because it gets worse. A man answered and Mr. Rat lowered the shotgun. The man entered the house. Mr. Rat told the man that he'd almost shot him through the front door. Kinda rude. Then, without further ado, Mr. Rat discharged the gun into the ceiling near the front door. The complainant began crying, which seems like a reasonable response to things here. She grabbed her keys and said that she wanted to leave the house. Reasonable. Mr. Rat told her that she was weak and that she could not go. Mr. Rat fired a second round into the ceiling. He then forced the complainant to go into a bedroom with him. Now, I'll just note, there are no charges here that relate to, him doing anything that you might be imagining in that bedroom. It's just unlawful confinement by making her go in there. So if that's what you're thinking, that doesn't appear to be the case. All right. Because of these and other events, Mr. Rat was convicted of 9 offenses. And so he gets convicted on lots of stuff. But notably, those include possessing a firearm without being the holder of a license under which he may possess it. So he didn't have a firearms license. And possessing a firearm while he was prohibited from doing so. So he also had a firearms ban. Somehow he still gets a hold of a shotgun. Because, bans are not necessarily the most useful here. Side rant, let's carry on. However, Mr. Rat was acquitted of the charge that he intentionally discharged a firearm, being reckless as to whether another person is present in that place, contrary to Section 244, sub 2, sub 1, sub A of the Criminal Code, and the Crown appeals from this acquittal. So they got him on 9 charges. They want that 10th charge. And the reason why they want that 10th charge is that this is actually a really big charge. It comes with a real substantial mandatory minimum. So they want him bad on that one, because that's one that they can sort of use to ramp the sentence way up. All right. So because this is an appeal, they're going to look at the trial decision, because the trial decision gets to set what the facts are, unless there's some really egregious error. And they're also going to look at the reasoning of the trial decision to determine if it should be thrown out. So the trial judge began his oral reasons in relation to this charge by observing that the evidence was clear that the firearm was discharged upwards into the attic. He found, though, that he had no evidence that this was a place where any person was present or could possibly be present. When you think about it, people don't typically hang out in the attic. It's not sort of a place where you gather socially or anything like that. My attic is pretty miserable as a place to be. Lots of attics, blown in insulation and that kind of stuff. So, I mean, maybe the Crown could have called evidence to say that there was a person in the attic. That would have been open to them, but there wasn't any evidence of that. Now, the Crown was relying on some cases, and the trial judge says they're not really applicable because they apply different circumstances, and we'll just kind of skip over that because the court's going to do a pretty full analysis here. So, issues, the outcome of the Crown's appeal is dictated by the answer to two questions. We're only going to look at one of them, because the first one is, does the Crown's appeal involve a question of law? Remember how I said that the Crown only can appeal on a question of law? Well, the court says, yes, this is a question of law. And I think that that is the obviously correct decision here. And it notes the second issue is, does the requirement in that section that a firearm be discharged into or at a place mean that it must be discharged from one physical place into or at a different physical place? Okay, so skipping over all that law stuff, we're going to get to the actual statute that we're looking at here. So discharging a firearm with recklessness. This has an A component and a B component, and these are basically two different crimes. They are similar in terms of what they're trying to prevent, but they have different tests, different elements to them. So discharging a firearm, recklessness. Every person commits an offense, A, who intentionally discharges a firearm into or at a place, knowing that or being reckless as to whether another person is present in the place, or B, who intentionally discharges a firearm while being reckless as to the life or safety of another person. So when you look at this, this is two separate different crimes. Paragraph A there is saying anything where you're shooting at, a place. So that could be a house, that could be a car. We're going to see the definition of place there, but into means if you shoot and it actually goes into the place, that's a crime. But they also say at, and at is going to get some argument here because the Crown is going to argue that at means that you can be in the place. And, if you are at that place, then that is enough. Whereas the defense here is arguing that at it means sort of how you'd normally understand shooting at something. If I say that I'm shooting at Bob, it doesn't mean that I'm inside Bob. It means that the gun is pointed in Bob's direction and I'm probably trying to kill Bob. So that's our normal understanding of at, but the Crown here is trying to adopt a bit of a different one. Why would they put in at when they already have into? Well, let's imagine that you live in a bunker, and it's a big concrete house, and, I shoot at it. Well, they don't want to cut me a break on this one just because your house is really durable, and they don't want the Crown to have to actually prove that the bullet penetrated into the house each time if they know that I drove up to it and leaned out the window and shot 6 times in the direction of your house. They're saying that should be enough. So the second one you'll see for paragraph B has no requirement that you be in a place at all. It's just any time you discharge a firearm while being reckless as to the life or safety of another person. So let's say there's a big crowd of people outside and I point a gun at the crowd and I shoot. And I get lucky. I miss everybody. But I was still being reckless because I'm shooting into a crowd. That would count under this and get me into a whole lot of trouble, even though I hadn't actually hit anybody. Now, the definition of place is interesting because place means any building or structure or part of one, or any motor vehicle, vessel, aircraft, railway vehicle, container, or trailer. So this covers planes, it covers trains, it covers boats, it covers cars. Please don't shoot at aircraft or any of these other things. That's really not cool. But it also covers, a house. It covers the living room, the bedroom separately. Those would be different places. It covers an outhouse. It covers a shed. All sorts of things. So a conviction under this section brings with it a mandatory minimum sentence prescribed in subsection 3. In accordance with that provision, every person who commits an offense under this section is subject to a punishment of imprisonment for a term of at least 4 years, and in some cases longer. So you'll see here, every person who commits an offense under subsection 1 is guilty of an indictable offense, and if a restricted firearm, which is handguns, or a prohibited firearm, which is a category that keeps growing in Canada, is used in the commission of an offense, or if it's committed associated with organized crime, then you can face up to 14 years and a mandatory minimum of 5 years in the case of a first offense, or 7 years in a subsequent offense, or in any other case, up to 14 years and a minimum punishment of 4 years. Now, 4 years is a lot of time. So this is why the prosecution wants to peg this charge on Mr. Rat, because they don't want him getting less than 4 years. They want to really make sure that he gets a lot of time here. All right, so the proper interpretation is a question that the court is looking at here. The Crown's position is that by interpreting section 244, that section, as requiring that a firearm must be discharged from one physical place into or at a different physical place for the offense to be made out, the trial judge read into the provision something that is not there. In making this submission, the Crown points out that it did not allege that Mr. Rat had committed the offense by shooting into the attic. Instead, its theory was that he committed the offense by discharging the gun into or at the ceiling, which is part of the house or its living room. The Crown says that the other way to look at things is that Mr. Rat discharged the gun at the house's living room, where the word "at" identifies Mr. Rat's location where he fired the gun. Now, again, this really doesn't seem to fit with how we describe shooting at something. You know, if I say I'm shooting at an apple, we don't think I'm inside the apple. If I say that I'm shooting at an airplane, and you ask somebody to say, where am I standing if I'm shooting at the airplane, they would probably say literally anywhere other than inside the airplane. Normally we understand shooting at to be the destination of the projectile, not its origin point. So that seems like a bit of a reach, Crown. Just a bit. So the Crown says that it does not matter if Mr. Rat knew or was reckless as to whether a person was present in the attic, and his own location was irrelevant to guilt or innocence because Mr. Rat knew there were others present in the living room when he fired the gun. So it just says, hey, so long as he shoots at, inside the living room, that's enough. So in advancing these arguments, the Crown urges this court to adopt what it submits is the clear or plain meaning of the words into and at, as well as the statutory definition of the word place. Now, I mean, I've already covered that I don't think that this is the plain or clear meaning of what it means to shoot at something. I've never heard anybody saying, shooting at something meant that you were at the place. So, I say I might be at the gun range, but I shoot at the targets. So, yeah. For his part, Mr. Rat, I might say that I went shooting at the gun range, but it's still, when I actually describe the act of shooting, I would say I'm shooting at targets, even if I might be at the gun range myself. So, it seems to me that the Crown is trying to stretch the definition here, and the court's going to agree with that. For his part, Mr. Rat supports the trial judge's interpretation. Of course he does. The trial judge acquitted him on this, so of course he supports that, which he says comports with the intended limited purpose behind the enactment of the section, as revealed in parliamentary debates. So we're going to actually look at, what Parliament was saying when they were enacting this, which is a perfectly reasonable way to argue it. Now, that isn't definitive. The court gets to actually make the final call, but it is evidence that the court can look at. He defines this purpose in his factum to be to criminalize those who intentionally shoot a firearm, appreciating that doing so may put a person at risk by shooting at an occupied place. when you think about what they're trying to capture here, it's really drive-bys, right? This is where where somebody pulls up and shoots a gun at somebody else's house a bunch of times and then speeds off, right? That seems to be what they're trying to capture here. All right, so I'm going to skip over a whole bunch of them going through the dictionary. I kind of already explained it, and otherwise this video is going to be real long, and not everyone's got the patience for one that's real long. It's still going to be moderately long. So I take from the differences between the A section and the B section, remember how I pointed those out earlier, that Parliament was seeking to criminalize two different types of dangerous conduct. As noted, Section B requires the Crown to show that there was recklessness as to the life or safety of another person. In contrast, by subsection A, Parliament was seeking to prohibit a specific type of conduct that was inherently dangerous to other people. Drive-bys. This provides the explanation for why conduct may be criminal under subsection A, even if it has not been shown that the person responsible for discharging the firearm was reckless as to the life or safety of another person. So, if you think about this, let's say I drive up to, somebody's house and I don't know if anyone's home or not. And it turns out that they're not, right? It turns out that they're not there. So I can't really be endangering the life or safety of another person at that point. But I still go and I fire, a number of shots into their house. And so I'm reckless as to whether or not there was another person there. Or perhaps another example is, let's say that person happens to have a safe room or a basement. They're in the basement and I shoot at their house. They're fine, right? They're in the basement. There's no way that I'm going to get through that level of dirt and concrete and so forth to actually hit them. But because I'm shooting into their house and they're there, that in and of itself is something we really want to prevent people from doing. So that's why that's criminalized. All right. So, considering this purpose, the court should favor an interpretation of this section, that's the A section, that is consistent with the idea that Parliament was intending to criminalize conduct that is inherently dangerous, but not more benign actions. And the more benign actions is going to be important, because we'll get to that. In my respectful view, the Crown's proposed interpretation of the A section is not consistent with this purpose. According to it, every discharge of a firearm within a building when a person other than the shooter is present is criminal, even if the situation is not dangerous. You can see how bad that would be. And the court's going to go on to give some examples here. Thus, it would be illegal for a person to discharge a firearm in an indoor gun range with other people present, even if it can be done in a safe manner. And, so you're at a range, you've got somebody who's, two bays over, you fire the gun. And you're not shooting at the guy who's 2 bays over, you're shooting at the targets downrange. And this is about the safest possible setting to do so. But they would say, the Crown's interpretation would make that a crime with a 4-year mandatory minimum. Go to jail for 4 years for shooting at a gun range. And they say indoor gun range, but in fact, lots of outdoor gun ranges in Canada have little shelters built. The one I shoot at has little outdoor shelters because it's Canada and, it might be real cold. And it's a lot nicer to shoot in a shelter where you might have, say, rain or snow that's being kept off your head by this shelter than it is to just shoot in the, the outdoors. So all of that is a little difficult to fathom that was the, we sort of presume that Parliament is making laws out of, in some sort of sensible fashion, that they're not drunk or actively malicious when they're passing laws. But, saying that it would be illegal to shoot at a gun range if somebody else is present is just weird. Similarly, a farmer would commit a criminal act by discharging a rifle in a barn to kill a varmint if another person was present, even if this can be done without creating danger. Seems weird, right? Likewise, if the word at is interpreted in the locative sense that the Crown promotes, i.e. being present at a place, then every hunter shooting from a duck blind is potentially committing the offense if another person is present with them. Show of hands, who's gone hunting with a buddy? Yeah, that's real common. So, this would also mean, as much as I don't support truck hunters, I think truck hunters can be dealt with wildlife offenses and not 4-year mandatory minimums if somebody shoots out of the window of a truck that's being driven by their buddy. Like, if they're assuming that they're shooting at game and not like, downtown. So, yeah, the court is a little skeptical of the Crown's interpretation when it can be applied to these kinds of scenarios, right? And of course, because these kinds of scenarios suggest that the Crown's interpretation here is, let's go with flagrantly wrong. Like, not just a little bit wrong, but flagrantly wrong. And I think that this is one of those places where it's really easy to get to sort of talk yourself into a bad position. And I suspect what happened is that they identified Mr. Rat as a really bad person. Like I said, he's kind of aptly named. So we really, really dislike Mr. Rat. We really, really want to get him. But we can't torture the law to do it. So that's kind of our problem here. And you can see sometimes, people ask, how can you defend criminals and so forth? Well, you might really hate Mr. Rat, but if Mr. Rat had been convicted on this one, the next people in line is Mr. Duck Hunter and Mr. Target Shooter and Mr. Farmer, as the court identifies. So sometimes this is really important. All right. Not only would the Crown's interpretation of this section criminalize these kinds of activities, regardless of whether the situation is inherently dangerous, but the person committing the act would be subject to the mandatory minimum penalty prescribed in the later section. The court should be particularly disinclined to favor an interpretation that not only criminalizes benign conduct, but imposes such a stringent consequence. Yeah, this is court language for, are you kidding me? Carrying on, because they're going to address a Crown's response to this. The Crown responded to the concern that a broader interpretation of the A section there would expose people to mandatory minimum sentences for acting in a way that is not dangerous, by submitting that if a person was convicted of a crime under that section in a benign circumstance, they could seek a constitutional exemption from the application of the mandatory minimum. I want you to know that seeking a constitutional exemption from the mandatory minimum is not going to be cheap. That's an expensive proposition, and also not guaranteed, as the court will note as we continue. Leaving aside the availability of this relief, i.e., maybe you don't even get that, the argument does not satisfactorily explain why this court should interpret that section as criminalizing such conduct in first instance, when there is another and more reasonable meaning that can be assigned to Parliament's words. Like the notion of, listen, we want to convict every duck hunter who goes duck hunting with a buddy, and then they can fight to get a lower sentence than 4 years, is nuts. Like, that's just not how the court should do things. And quite frankly, the court gets it right here. The trial court got it right, and then the Crown appealed, and the appeals court is like, nah. And you know what? If this gets appealed to the Supreme Court, I have a very strong suspicion that the Supreme Court would go, nah. In fact, I think that the Supreme Court would say, we are declining to take this case. Thank you very much. Goodbye. Yeah, it just makes no sense that, when I go to the gun range and I shoot my handguns, if there's a guy next to me at the range, that I should be looking at a 5-year mandatory minimum. This is where we expect me to shoot handguns. This is where, it makes sense that people would go target shooting at the range, and we can't all have an individual range. There can't just be the Runkle of the Bailey range that is just for me. I mean, that would be cool. Maybe if I, get super wealthy, but no. And you shouldn't need to be super wealthy to go target shooting. All right. A more sensible interpretation of the section is found by understanding its purpose somewhat more narrowly than the Crown describes. This is a little bit of judicial snark. This purpose is, as the trial judge found, to criminalize the discharge of a firearm into or at a place in circumstances when the shooter is at one location and knows or ought to know or is reckless as to whether people are present in the place at or into which the shot is fired. Knowing that or being reckless as to whether another person is present in the place, emphasis added. Therefore, by way of example, Section 244 sub 2 sub 1 sub A criminalizes conduct such as drive-by shootings at homes or buildings. It equally criminalizes conduct like shooting at passing cars. So that seems reasonable to me. Now they're going to look a little bit at the history of the section, and this includes some parliamentary debates. This is the Honorable Rob Nicholson. Honorable is sort of the title that we apply to many politicians, whether or not they actually are. I have no comment on this particular one. I'm just noting that that is sort of how we talk about politicians. So to quote here, and I'm not going to read the full quote. The full quote is real long. The second area of reform relates to drive-by and other reckless shootings. We're proposing a new offense be added to the criminal code that would target all intentional shootings involving reckless disregard for the life or safety of others. So you see what they're trying to capture there. And they distinguish between drive-bys and other reckless shootings. It's real clear what they were actually looking for, right? They're not trying to criminalize going to the range. So finally, the Crown argues that a restrictive interpretation of this section ignores the risk that a person creates by discharging a firearm in an enclosed space. The thing is you don't necessarily create a risk by discharging a firearm in an enclosed space. The duck hunter shooting from the duck blind probably isn't creating a risk, because if he was, he probably wouldn't be shooting from the duck blind. If I went to the range and I thought the range was dangerous, I would not stay there. I would leave. I, in fact, go to shoot at the range because it's a particularly safe place for me to shoot. So, carrying on, brought into the circumstances of this case, it referred to the danger of ricochets and so on to the people present in the living room where Mr. Rat fired the shotgun. The Crown invited the court to conclude that Parliament intended to criminalize shooting within a building to suppress this very kind of dangerous activity. The answer to this last argument is that it will always be open to the Crown to seek to prove that a shooter in Mr. Rat's position was reckless as to the life or safety of another when he pulled the trigger, and thereby committed the offense created by the B section. However, the Crown did not set out to do this in this trial, which it might have if it felt his conduct met the standard. It's like, Crown, you have an entire section for this. You could have used that if you thought, and now you basically want the court to give you a do-over on that and to convict the guy on that section that you never actually charged him with and that he wasn't, defending against in that trial. How is that fair? How is that reasonable? So I'm not prepared to give an unnecessarily expansive interpretation to the A section simply because the discharge of a firearm within a room may sometimes involve danger to the life or safety of another person, when another provision of the criminal code already serves the socially necessary purpose of criminalizing such dangerous conduct. If it's dangerous in the specific time that you are looking at, then you charge that section. And the reason why the Crown might have had some trouble there is that you might want to actually, in that case, prove issues like the danger of ricochets, and that might be a little harder, but you have to actually do the work. And you don't get a freebie just by getting the court to take this weird interpretation. So in conclusion, on the question of the proper interpretation of the A section there, to make out an offense under that section, the Crown must prove that a firearm was discharged from one physical place into or at a different physical place. So, yeah, and note that a different physical place here doesn't necessarily mean you're shooting from one house to a neighboring house. It can be that you're shooting from one room into another room. That's a perfectly acceptable way to get to that conviction. And in fact, they give some examples there. One of the examples is a situation where somebody goes up to the second floor. Here, I'll just bring it up here. So this is the case of Vezina out of Quebec. And the accused in that case got into an argument with his spouse and then discharged a firearm 15 times inside their two-story residence and was convicted under the A section. But the critical thing on that one is that he was on the second floor of the two-story dwelling. His spouse was on the ground floor when the shots were fired, and he fired from the second story down into the first story. So from one place into another. Now we're getting into that conduct of you're shooting into a place and you don't really know where everyone is. You're really running an incredible risk that someone's going to get shot. So that's, a different scenario here than somebody who's shooting. When you think about it, Mr. Rat was obviously, a pretty terrible person. What he's doing is pretty awful, but at the same time, he's in a one-story building, right? And he's shooting up into the attic where he's going to be pretty sure there's nobody there. It's a very different level of severity than if he had, say, fired through the door at that knocking sound, or if he had left the house and then turned around and just fired blindly into the house, right? That's a very different scenario. The risks that are posed by him sort of shooting blindly into that house are way more serious than him shooting into the attic. Not saying it's great conduct, but yeah. This case is one of these examples of just how precarious our society can be in some ways. Because one bad decision, and in this case we've got a good decision, but if this case had gone the other way, we would have real problems. You might see ranges having to redesign such that everyone who's shooting, each bay has a little enclosed space, like a porta potty to shoot out of. And that doesn't sound nice. Indoor ranges are already a little bit more unpleasant than many outdoor ranges because they're noisier. You are shooting in an enclosed space, which means you get more reflected sound coming at you. It can be a little unpleasant. And, this notion that now you'd have to be sort of in this little tiny box, I don't like that at all. And how many ranges would actually be able to set this up? This would be just the unintended consequences if this was, approved, would be just wild. And, these cases come up from time to time. There was another case that I covered in a previous video that looked at whether or not knives would be considered illegal or should be considered, intended for use as a weapon if they have a locking feature such that they lock open. And the judge in that case quite properly said, wait a minute, that makes no sense. There's plenty of reasons why you'd want a knife to lock open, like not cutting off your own fingers if you have a slip with it, that aren't sort of weapon purposes. But the law you can sort of imagine as kind of a river that flows, and as it goes, it might hit an obstacle and decide to go one way or the other. And sometimes it's really, if it goes one way, it's going to go through the forest and nobody's going to really be bothered. But if it goes the other way, it's going to go right through, the village, and it's going to start washing people away and causing a whole lot of havoc. This is one of those times where it's like, this really could have gone the wrong way, and it would have been a really big deal. And I don't think our current government would have rushed to fix it. So, yeah. Anyway, thank you guys. I really wanted to share this case with you. I thought it was an interesting one, both for the sort of perspectives on the legal tradition and how we get to our sort of legal rules. I also like the analysis in it, and it's kind of a happy story. We don't always have sort of happy stories on firearms things, but this one really kind of works out. The law is preserved in a way that doesn't create a whole lot of problems for people. And I mean, ultimately, you might be saying, well, I don't like that Mr. Rat was acquitted on this one. Mr. Rat was convicted on lots of stuff, and I think Mr. Rat is going to be in a small room for quite a while. And nobody's going to be giving him a shotgun there. So nothing to worry about for at least a little bit. Anyway, thank you guys for watching. I really hope you found this one to be interesting or educational. Please hit the like button, leave a comment. If you have a question, I'll try to get to it, but just comments really do help with the whole algorithm, engagement of any sort. Basically, clicking any of the YouTube buttons helps. And please also share this video with your friends and subscribe if you'd like to see more content. I also want to thank my Patreon supporters at the $50 level, the CCFR, Canada's National Firearms Association, the Canadian Shooting Sports Association, and David Michaud. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Mark, Lindsay Metcalf, Kyle Fox, Haywire, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, and Vicky. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.